Today, we are diving into a really important piece of U.S. immigration law. It's one that was specifically created to offer a lifeline to people who are trapped in some of the most difficult situations imaginable. And this quote, well, it just says it all, doesn't it? It's about that impossible choice so many non-citizens in the US face. They're stuck in an abusive relationship where their entire future, their legal status, is completely controlled by the person who's hurting them. So let's get to the heart of the problem. You see, this isn't just about domestic abuse as we typically think of it. It's about a really specific hidden power imbalance where immigration system itself can be twisted and used as a weapon. Think about how it usually works. A US citizen spouse or parent is the one who files the immigration papers for their relative. Well, that dependency, it creates this huge unspoken power dynamic. An abuser can just hang the threat of deportation over someone's head, leaving them feeling completely trapped and alone. Yeah, this quote just captures it perfectly. It's the feeling of hopelessness where someone's immigration status is used as the ultimate tool of control. But the good news is that Congress recognized that this was a huge problem, and way back in 1994, they created a very specific solution to fight back. And that solution is called the Violence Against Women Act, or VAWA for short. It basically created a secret backdoor, a legal pathway for survivors to get out from under their abuser's control. When it comes to their immigration status, it's a process called self-petitioning. And that name is everything. It means a survivor can file for legal status all on their own without their abuser knowing. And this is the most critical part. The abuser is never told about the petition. It's designed for safety first and foremost. Now, you might hear the name and think it's only for women, but it's not. VAWA protects survivors of any gender, but what's really revolutionary and what we're going to spend some time on is how this law defines what abuse actually is. For a VAWA case, the abuse does not have to be physical. The people who wrote this law knew that some of the worst kinds of harm are completely invisible. The legal standard they use is battery or extreme cruelty, and that phrase extreme cruelty is intentionally broad. What immigration officials are trained to look for is a pattern of behavior. They know how a series of controlling acts, which might seem small on their own, can add up to create this crushing, suffocating environment of abuse. And of course, one of the main weapons is immigration status itself. It's the constant threat to call ICE, the refusal to file the paperwork you need, or even just lying about your rights in the first place. It's all designed to create this constant state of fear and make you feel like you have no options, and that control, it just spiders out into every part of a person's life. It could be controlling every single penny so you can't even buy a bus ticket. Or it could be isolating you from your family and friends and your support system until you feel like the abuser is the only person you have in the world. And then you have the psychological warfare. We're not just talking about arguments, we're talking about deliberate tactics, constant insults, threats about your kids, destroying things you care about, all designed to chip away at your self-worth and make you feel like you're going crazy. It is just as damaging as any physical harm. So who can use this path to safety? Well, the eligibility is very specific, and it all comes down to the family relationship you have with the person causing the harm. So here's the deal. To be eligible, the abuser has to be either a US citizen or permanent resident, what most of us just call a green card holder. The law targets these specific relationships because that's where the abuser has the ultimate leverage. Because that's where the abuser has the ultimate leverage. That ultimate power over someone's ability to stay in the country. So this brings us to the next logical question, and that's a huge one. One thing to know about who is eligible for VAWA is about the relationships, right? Abused spouse of a U.S. citizen or permanent resident is eligible. One thing I want to say about this is if you are getting a divorce or you are already divorced, you need to make sure that you are filing your VAWA application within 2 years of that divorce. So not if you're separated. So I've had couples that have been separated for like years and never actually went through the process of getting a divorce, still be able to file for VAWA. But if you do go through that process of getting a divorce, you literally have 2 years from the time you got the divorce that you need to file for VAWA, or it's no longer an option. So it's really, really crucial that you take that step as soon as possible. Also, if you are the parent of a U.S. citizen and your U.S. citizen child is abusing you, it's important to know that you cannot apply for VAWA unless that U.S. citizen child is 21 years old or older, and of course, a U.S. citizen. So if your child is a permanent resident and is abusing you, unfortunately, VAWA would not cover you. But if the child is a U.S. citizen and over the age of 21, then you would be covered. I always want to say those because they are caveats to the requirements, and I want to make sure that you know that in case you are close to your 2-year deadline or your child is not a U.S. citizen yet, you want to have that information and so that you can go ahead and file. How in the world do you prove something that doesn't leave bruises? How do you show a government agency a pattern of fear and control? This is probably the single biggest myth that VAWA has. People think you need a police report, pictures of injuries, but that's just not true. The law specifically says that immigration will consider any credible evidence. They know that abusers work in the shadows and that victims often are way too scared to call the police. This standard gives survivors a real chance to prove what is happening. You build a strong case. By layering different kinds of proof that all tell the same consistent story, it all starts with your statement. Your story is your own words. Then you add to it. Got threatening text messages? Include them. Did a friend see what's going on? They can write a statement. And the report from the therapist showing the psychological impact, that can be incredibly powerful evidence. So once you file that VAWA self-petition, it's done on a form called I-360. You start this multi-step journey. So let's take a look at what that path generally looks like. But before we get into the timeline, let me just say this again, because it's the most important thing to know. This whole process is safe. It's 100% confidential. Your abuser will not find out. The system is built to protect you, okay? While these timeframes can definitely change, the structure is what's important, okay? Once you file your VAWA I-360 application, the first thing you're going to get is a receipt notice. So basically a document from USCIS saying that they have received your application. Pretty early on after that, you might get something called a prima facie notice or prima facie determination letter, which is basically a first look that says your case seems credible and it can unlock some public benefits for you. Then the big approval, which can take a while, several years in some situations. It gives you something called deferred action. That is huge. It protects you from deportation and allows you to get a work permit. And from there, you are on the final path to applying for your green card. Now, if you are married to a U.S. citizen, you may be able to apply for your adjustment of status, your green card, at the same time as your VAWA petition. But that is really going to be dependent on what the person, your abuser status is at the time you file your I-360. But if you're in a situation where you are able to file your green card application with your VAWA application, Then one thing you can add to that is an I-765, which is a work permit. It will give you the ability to work in the US while your VAWA application is pending, while your green card application is pending. So that is going to be a different time frame for you. But as far as the VAWA itself, this is the time frame that you're going to see. The VAWA application right now takes from 3 to 4 years for just the VAWA itself. And it may even start taking longer because USCIS is now pulling some VAWA applications for interview before the VAWA is approved. Typically, your VAWA case is approved and then you have a green card interview. But right now, we are seeing that some VAWA applications are getting interviewed before a final decision is made on the VAWA case. So I am thinking that this is going to lead to a longer wait time from filing to decision. But just know, this is something that's happening. So if you get a notice saying that you have an interview for your VAWA case, it is normal. It is something that's new, but it's definitely happening and it's not fake. Okay? And you need to prepare for that interview. Look, just knowing that VAWA exists, that it's confidential, and that emotional and psychological abuse absolutely count, that knowledge can be the key that empowers someone to find a way out. I have done a couple videos on my channel, go back and look at them, where I talk about financial abuse, economic abuse, and psychological and mental abuse because they're so important, they're so prevalent in almost all abuse cases that I see that I wanted to cover them separately. But just know, in the process of thinking about abuse, in this video, I'm talking generally about VAWA, what the requirements are, but just know that when you want to really do a deeper dive, I do have videos where I talk about the different forms of abuse and what you can use to prove those forms of abuse. But psychological evaluation is a huge thing that if you are in the process of applying for VAWA and you just don't have anything else, getting a psychological evaluation can be a game changer. And also, getting into therapy can be a game changer for your life, okay? Sometimes we think about what will be good for the case, but I also think about what would be good for the person applying for VAWA. You need to find a way to move forward in your life, and getting into therapy is a way to do that. And most of the time when I get back psychological evaluations, the therapist that does the evaluation is recommending that that client get into one-on-one therapy because they know it will be beneficial to the client. So just know, yes, get a psychological evaluation, but also get ongoing therapy because that's what's going to help you heal and be able to move forward in your journey. For most people, just knowing that this option is on the table can be a real lifeline. You don't know how many people have come to me crying because they didn't know how to move forward. They thought they had to stay in their abusive relationship because their spouse kept promising that they will get them a green card, that they will finally, after years and years and years of being in a relationship, take those steps to get them status in the US, and just never did it. And they're crying because they have spent their whole life with this person and being severely abused by this person and not knowing that this option actually exists, that there is an option that will make it so they can get their green card without their spouse being involved, without them remaining in the relationship. If after watching this video, you think you may want to speak with an immigration lawyer to figure out your options if you qualify for VAWA, what type of evidence you may need, feel free to reach out to me. You can schedule a free strategy session with me by going to my website, lilylegal.com, click on contact us, and you can pick a date and time that works best for you for us to talk about your situation and see if we can get you that freedom that VAWA promises.